just in my rehearsal room. Hold on, hold on, hold on, hold on, hold on, hold on, hold on. Everybody hold on, hold on, hold on, hold on, hold on. Robert is coming home. He's coming home. Hold on. Everybody hold on. Robert is coming again. He's coming home. Hold on. Everybody hold on. No matter what they say, no matter what they do, no matter how it seems, God's got the final say. It doesn't matter how long it may seem, the end is what matters. But God's got the final say. So hold on, everybody, hold on, hold on, hold on, hold on, oh, hold on, hold on, forever, hold on. The enemies may hate, they can tell all lies. No matter how long, the truth will prevail. They can rise up against all the fans that stand up for him. The end will justify, for God has the final say. Oh, no, 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 yo. Hold on, hold on, hold on, hold on. Robert is coming home. It's coming back, so hold on. All fans, hold on. 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 Help is on its way. Heaven is down here. Hold on. All fans, hold on. God is here. Taking it over. Hold on. Everybody, hold on. Hold on. Hold on. Hold on.
Good evening, everybody. I thank you guys for coming out this evening. I'm going to have my readers to come on in, Miss Melanie, Miss Mel, the only Mel Cruz, and as well as my girl, Purple Couch. We're going to be discussing a couple of things this evening, but first, I want to thank both of them for just at the whim of the second, I asked them to come in and they oblige. Hey, ladies.
Hey,
Hey.
Sylvie. Hey, Purple Couch.
Hey, how you doing, man?
Doing good,
Sylvia.
girl.
Hey, okay. First, I want to thank everybody in the chat. You know how it is. When things pop up, something new comes in, I'm going to bring it to you because you know why? Infamous Sylvia is on the case.
On the case.
Hey.
There's a couple of things we want to discuss tonight, but first, we want to acknowledge the relentless, strong fighter that Robert has as his lawyer, Miss Jennifer Bonjean. She don't care what time of day it is, what part of the weekend it is, she's on the case. She has filed a reply, even though she wasn't even supposed to file a reply. But Bonjean is on the case. So she just recently replied to the government's objection to the extension of the, to prolong or temporary adjourn the sentencing hearing. Yeah, thank you. I just had a brain fart for a minute. So she has come on and did another punch. She powwow. Psh, psh. So I just want to talk to you guys about that. And then a couple of things that's been going on in the world of the R. Kelly case, in regards to that young lady, Azriel. We're going to discuss that too. Two occurrences, her interview as well as the young man who just put out on Front Street a few hours ago. So we're going to talk it all. We're going to talk about it all. But before that, we're going to talk about the more important thing, which is the motion, the reply that Bonjean put in. And also, we're going to replay that HN report earlier. I'm going to play that. So it's a lot of things we got to do, but we're going to head and do it. Whichever young lady ready to read it for me, please do so. Y'all pick which one.
Melly Mel.
All right, Purple Couch. Okay, so this is dated today. It's going to Judge Ann Donnelly. Dear Judge Donnelly, please accept this short reply letter to the government's letter dated April 7th of this year. Defendant does not contend that a Miranda violation will occur if his sentencing hearing proceeds before resolution of the Illinois case. Rather, defendant argues that to provide fulsome mitigation evidence, he will have to waive his Fifth Amendment right, and that carries serious risk. Defendant maintains that it is fundamentally unfair that he should have to make that choice when so much is at stake. Second, defendant appreciates that all defendants who have been convicted of an offense run the risk of self-incrimination when they participate in the sentencing process. But this case is unique and distinguishable from De La Pez. First, defendant is not seeking a continuance of his sentencing hearing merely so he can exercise his right of allocution, although his right of allocution is unquestionably compromised if his sentencing proceeds before the Illinois case. Rather, defendant seeks a continuance so he can speak more freely to a mitigation expert about his own history and develop evidence that may shed light on the offense conduct for which he has been convicted. Second, because the offense conduct in this case spans decades and overlaps with the charged conduct in the Illinois case, the risk of self-incrimination is particularly high. Again, sentencing in this case would involve discussion of defendant's life and character, not merely isolated incidents. For that reason, this court should have a full understanding of who Robert Kelly is. The one-dimensional portrait the government has painted does not tell the complete story. Because the government has labeled every person in proximity to defendant as members of his inner circle and enterprise, many individuals who could and want to provide mitigation information about the defendant are fearful of doing so. Thus, defendant is his best source of mitigation, but he feels limited in his ability to do so with the Illinois charges pending. The defendant understands that his sentencing hearing cannot be postponed indefinitely, nor does he ask that it be continued until resolution of every state court criminal and civil matter he faces. He merely asks that in light of the serious federal prosecution that is scheduled to commence August 1st of this year, this court grant a slightly longer adjournment. Granting this adjournment would appropriately balance defendant's guarantee of a fair sentencing hearing with the interests of his accusers, who will get their opportunity to be heard publicly. Should the Illinois case get postponed, the government would be free to object to any further adjournments, which defendant accepts would likely be sustained. Respectfully submitted, Jennifer Bongine.
All righty. All righty. Thank you so much, Mel, for that reading. What do you think about the letter? The response?
I like it, and she's sealing every crack, every nook, every cranny. That's really what she's doing.
Definitely.
I agree. What do you think, Purple Couch?
Yes, I definitely agree. And she's making sure that, for any possibilities or changes, she's trying to be gracious and stating, I will understand that, you may not grant any additional adjournments, but I do thank you and ask for this, so she's really trying to make sure that everything is done gracefully, yet, kind of like we do need this.
Yeah.
Right. And I think too, she's preserving, because all of this can be appealed because why would you put him in this situation where he could incriminate himself? So I think an appeals court would look at that and say, oh, come on, that's, law school 101.
Mm-hmm. Mm-hmm.
Definitely.
Yeah, definitely. Well, okay, guys. I'm gonna play something, and then we're gonna start our discussion of everything that's been going on this week. So just one moment. I am going to play this. We do not own the rights to this, but we're doing it as the Fair Act. Let me just put my little disclosure up here. Copyright disclaimer. Under Section 107 of Copyright Act 1976, allowances made for the fair use for the purpose such as criticism, comment, news reporting, teaching, scholarship, and research. All right, guys. So we're going to go ahead on and play this wonderful hold on. I thought this thing was excellent this morning when I heard it. I played it early, and I'm going to play it for you guys so you guys get a chance to hear what this station has says. Hold on.
Download the Domino's app today and become...
Sorry. I got the commercial one on. Hold on.
That's all right.
Let me get away from the commercial one. Let me get the one that's not commercialized. I was looking at it from my second channel. And I gotta go for the infamous Sylvia, where there's no all right, here we go.
Time for a pre-sentencing report to come in.
Oh, listen.
You are welcome to HN What's Your Say? The #1 listening show, where we discuss real issues with real people like you. We are still featuring R. Kelly. A few days ago, R. Kelly's new attorney, one Jennifer Bongine, made a request to Judge Ann Donnelly that her client's sentencing be postponed to a date after his Chicago trial scheduled for August. According to Bongine, this will prevent R. Kelly's pre-sentencing mitigation submissions for the New York trial from being used against him in Chicago. Ann Donnelly, who is always so quick to respond, replied in opposition, saying that the sentencing date cannot be postponed to after the Chicago trial, because the accusers have been waiting for justice for a very long time. Nevertheless, she offered to extend it to June 16 to allow more time for a pre-sentencing report to come in. Exactly how this will likely affect the case, we are yet to find out. But speculations are already underway, suggesting this time lag could help the R. Kelly camp to negotiate down the assumed 20-year sentence to something a lot less, and later fight the remaining bit of this unprecedented judgment one step at a time. Bonjean, however, is still dissatisfied with a 1-month extension, and was heard saying the court seems more pronounced in defending mob justice, rather than serving justice to her client R. Kelly. Bonjean continues to fight what she termed as the violation of her client's rights, with emphasis on the Fifth and Sixth Amendment rights as follows. Both these provide protection to accused persons, and can well be taken advantage of by the defense to secure R. Kelly's freedom. The Fifth Amendment says that any serious criminal charges placed against an individual must have been started only by a grand jury. And this was intended to avoid confusion from documentary scenarios as we saw in the surviving R. Kelly series. The Fifth Amendment continues to say that a person cannot be tried 2 times for the same offense, something referred to as double jeopardy. It also says people have a right against self-incrimination, and cannot be imprisoned without due process of law with fair procedure and trial. Well, R. Kelly has been imprisoned now 3 years, and 2.5 of these was without due process. The Sixth Amendment right suggests a speedy and public trial by an impartial jury. In R. Kelly's case, first, the trial was nowhere close to speedy. It took 2.5 years before it could start, and it clearly wasn't a public trial like the law suggests. No media was allowed, and therefore the world was left in the dark of what transpired. Clearly both amendment rights were violated by government, and Bonjean is right to ask that the sentencing be extended until after the second trial. Trying R. Kelly twice both in New York and in Chicago will tantamount to double jeopardy, with an aim to pile onto his serving time. An early trial will also violate R. Kelly's Fifth Amendment right, where it says he has a right to avoid self-incrimination. Forcing him to submit his pre-sentencing mitigations before the second trial, something that could lead to self-incrimination, is a wrong thing to do. As Judge Ann Donnelly keeps bouncing back Bonjean's pleas, she ought to be careful not to put her reputation as a district judge in a crisis. The whole world is watching and following this case closely. It will be an embarrassment for her if her judgment is overturned in the appellate court. Meanwhile, there is an assumption that even if R. Kelly is freed from some of these charges, he still have to explain his alleged illegal marriage back in the years. What they forget though is that for a marriage to take place, one does not only present an ID, but birth certificates as well, which have not been mentioned anywhere as part of the evidence to prove he committed the crime. Bonjean, who is proving very conversant with the law, looks like she is beginning to get this case under control. She is the new hope for R. Kelly to regain his freedom, and is so far doing a good job digging for information and enactments she can use to her advantage. According to Maureen, this at last is something to celebrate in our camp. I hope it marks the beginning of a new chapter in this case, where we begin to win big and hopefully see this case overturned going forward. Bonjean is applying just the right pressure, and we hope to see even more and bigger results ahead. There are so many people who have been living in denial, saying R. Kelly's fate has already been sealed, and that sentencing is fixed for May 4th, not to be shifted. I hope this serves as an example to them of how successful Bonjean is likely to be with this case. I hope it makes them realize that anything is possible with this case. An additional month can help Bonjean get a window through which she can submit various motions to contest the September 2021 conviction, and hopefully cause the sentencing team to think a little deeper and contemplate their decisions before execution. According to Simon, this may not be the kind of extension Jennifer Bonjean is demanding, but we can't agree more. It's something to hold on to. It's been almost 3 years of no good news in the R. Kelly camp. This is a green light, finally showing us that even what so many think is impossible can happen. When I listened to the video that compared the government's interpretation of the RICO Act and that by Bonjean, I realized that there are indeed so many gaps in this case that, if well managed, can return R. Kelly the freedom he has been unfairly denied. Trying to understand what's going on within the government prosecution that is causing such loopholes in interpretation of the law, I realize it could be a conflict of interests. If the main resolve is to make sure that R. Kelly the bad guy gets the longest possible sentence, there is no way this can be coupled with proper legal interpretation. According to Miriam, I never expected that our legal system could in any way choose to violate a citizen's rights, all in order to implement their own agenda. It looks like decisions made are no longer based on the demands of the law, but the interests of individuals. This shift to sentiment rather than reason is a great danger for our system and our nation as a whole. What kind of values will our descendants inherit from us if until this era, we still cannot prioritize justice over personal agendas? If R. Kelly's Fifth and Sixth Amendment rights were respected, we wouldn't be discussing this issue. The sentencing would have been moved to September already without much question. But because abiding by the law does not look like the most important thing to do, the application was opposed. Even this 1 month delay is just a miracle from God. One may wonder, if served justice is what the authorities want the most, why would they be so in a hurry to sentence him given he has another trial on similar issues in Chicago? They were patient enough to keep R. Kelly in prison for years without trial, but they simply won't wait another 3 months to sentence him. Very interesting. That is all we had for you today on HN What's Your Say?
All right, Mel, what do you think
Yeah, he
about
said it
that?
all. He said it all. And, you know, he said it all. I'm glad somebody else is saying it too, because this really is, and, like I said, day one for me, in an interview with you, Sylvie, that, this really is a social justice issue. And it's so clear that Geddes does not care about, administering justice. She's just trying to get a win, and she has her own personal agenda. Lock him up. If he's black, lock him up. That's what I think.
I must agree with you. Purple Couch?
Yes, I definitely agree with both of you all. And the thing too is that it's just a continuation of disparities. We have the disparities in healthcare, we have the disparities definitely in the legal system. And this is blatantly an example of that.
Mm,
And even as far as the speedy trial, he was supposed to have a speedy trial or given that opportunity, and for him to be locked up for 2 years and wasn't even allowed that. And like he stated, I mean, come on, 2 years, no trial, and now you're going to rush through everything and with another trial. I mean, okay, it's still the federal government again trying to prosecute him again, in Illinois. So what is the big hurry?
right. What
What
is the rush?
Right. And then two, I'm kind of side eyeing the the judge too,
Okay.
because she is much more aware of the speedy trial um, law.
Right.
Mhm.
And it's not like you don't know that it didn't happen.
Mhm.
I mean, you know what I'm saying?
Right.
It's not like you didn't know it didn't happen. So I'm just and that Elizabeth character
Mm-hmm.
is a character. And now I think it's all about her personally. All of the laws and violations in her mind are out the window.
Mm-hmm.
She's on a vendetta now.
Mm-hmm. Well, and I think too they got used to, so Cal's first team, as jacked up as they were, I think Geddes got comfortable with their level of incompetence.
Yes.
And so, and
Speaking of a competence, I wanted to read. Do you still have that? Did I send you guys
when did you send it? I probably don't have it.
the letter that Doug Anton wrote out?
Oh, yeah.
Do you have that, Purple Couch?
I'm not sure. You said Doug Anton? Let me see.
I think I
You
sent
pull it
it
up.
to you the same time I sent it to Mel the other day,
Let me see.
of his motion that he had submitted. And I was like, wow, no wonder. This is during the pretrial
Mm-hmm.
motion for One second, I'll tell you what day I sent it to you.
Well, like I was saying while we're looking, they here, I think this might be it. Yeah, I got it.
You got it?
They, Getty's was just comfortable with their level of incompetence, and that's why a lot of this stuff slipped through, like the weak witnesses. The other thing with uh, Jane Doe number 5 being able to be on the visitation list, knowing good and well that Nicole was representing, serving as her attorney, but yet you guys made sure that she could go in there and talk to Kels. What were you bringing back to them based on your conversations?
Exactly.
Exactly.
You
Exactly.
know, and so she got comfortable with that level of incompetence, and the judge saw the incompetence of them not, objecting to certain things and whatnot. And so she let a lot of stuff go by. They didn't expect Bongine to pull up and just pull all the blankets off and say, now look at you.
Yeah. Yeah.
So she has to do what Bongine's saying, because Bongine is coming with case law and with fairness and equity.
Exactly. And it's it's not it's really nothing that you can kind of like debate
Exactly.
because it's all there in black and white.
And a real appellate court would look at that and say, wait a minute, why would you put this defendant in this precarious position of possibly um, incriminating himself? Why would you do that? This was a no-brainer. That's what the appellate court would say.
I
Mm.
agree.
Purple Couch, check your email. Mel, you got it?
Yeah.
Okay. So I want us to kind of discuss the incompetency of that letter. I know I'm being mean. I'm not being mean, but I'm just showing them facts of some things that was being said
Okay.
and
Let me
done.
refresh my thing. I haven't got it. Okay. Okay, I just got it. Okay.
Did you want to read it? And this is the pretrial motion that was done by Robert's attorney, Doug Anton, at the time. I just need you guys to listen to the type of motion, what was being said, how it was being said, and you guys be the judge of what. What do you think about this? You want to start, Purple Couch?
Oh, okay. This was July 30th, 2019. Okay,
Yes.
dear Judge Donnelly, as the court is aware, this office represents defendant Robert S. Kelly in the above referenced matter. I am responding to the government's July 12, 2019 letter in support of pre-trial detention of the defendant. While that letter sought for the defendant to be detained pending his removal to the Eastern District of New York and does not address pretrial detention specifically after being removed to New York, in my communications with the ASUA Gettys over the last week, it is clear that despite the different underlying predicate facts in our New York matter, only 2 misdemeanors involving an alleged adult victim, her office is still seeking a denial of any bail. While I agree with the government
Did
that
you
the
hear that? I agree
what?
with the government.
Wait a
I
minute, I had to
agree
stop.
with the government. Just keep reading.
Okay, that the allegations that have been created for this global case contains charges that are serious. Respectfully, each district court is permitted to address the specific charges before it when considering a fair and reasonable request to release a defendant pending trial so that he can participate in his defense, generate income to mount a proper defense, and enjoy the presumption of innocence until guilt is proven beyond a reasonable doubt by the government.
You heard that?
First,
Generate income.
yeah,
Generate income.
Hmm.
Just keep listening, y'all. Just keep
first,
listening.
let me address what the government calls the enterprise as its existence in the form the government is alleging, or really lack thereof, is a paramount and somewhat controlling dispute in this case. In short, the enterprise has been described by the government as the following, and I am paraphrasing and offering the real world description of what the government wrongly purports as its assumption, accusation in the indictment. Superstar singer Robert Kelly is a touring, multi-million record-selling musician, singer, and songwriter. He employs people and companies. Some of these employees are called managers, bodyguards, drivers, personal assistants, and runners, as well as unnamed and unidentified others. Some of these employees toured with the band from state to state. For example, lawyers and managers won't, but roadies and bodyguards might. Okay, I why did he put runners? I
Excuse me, I'm sorry. This
I
is
mean,
a
because
letter
right
to the
there, that
judge.
sounds, criminal. But anyway, while it is a tour per se, each show is an individual contract with a venue located within a state of performance with no multi state ties. The government has not identified any show venues, any employees, or any specific locations so that we could make this solely state specific contract fact argument for each show clear to the court at this time. Indeed, a rock and roll tour commonly uses in state security, drivers, gaffers, technicians, and other employees, making a tie to interstate commerce non existent except that one show is lined up after another on a tour. We will address that more when substantively challenging the wrong RICO and Mann Act tie ins by way of motions. However, we trust that Your Honor, hailing from very near the Motor City, the birthplace, Motown, Berry Gordy, Ted Nugent, and eventually Kid Rock,
Mm.
Marshall Mathers, Curtis Jackson, etc., is all too familiar with how a rock and roll tour works and will leave it at that.
Unprofessional and lame.
Woo!
Okay, why?
Woo!
That was totally irrelevant.
Right, and how does he know what she know?
Come on.
Okay, about rock and roll. Is she traveling with these people? I mean,
Woo!
Mm.
okay. The government then correctly defines that the employees for Robert were employed to promote his music and his brand. This is the essence of the professional's obligation when working with a recording artist. This is done in the offices of record companies and the like, not on the road as the government alleges. Next, despite
That
Robert
was a
being
good point, though, right there. That was a
right.
good point.
Right. Next, despite Robert being a world famous recording artist for the last 30 years, touring is in every country on the planet, working with every major superstar from Michael Jackson to Lady Gaga and selling millions of records, the government feels comfortable to describe what it has listed as only 5 Jane Does, not all of which are alleged to be minors, out of a public career of 30 years, as reasonably and legally fitting the description of a pattern of which intended purpose to recruit women and girls to engage in illegal sexual activity. We offer this description of intent and purpose as proffered by the government is an absurdity. Okay, that's a good one.
Solid.
Uh-huh. The indictment alleges, albeit in a different light, how these groupies sought out Robert's attention, even fought each other for it, voluntarily contacted him, came to his shows, pinned to be with him, and how Robert would spend his time and even become friends with and care about these groupies and fans who were dying to be with him. Mind you, evidence would show that the Robert Kelly tours and shows would accommodate both male and female fans with access to the singer, picture taking, meet and greets, fan events, backstage passes, and the like. The indictment even alleges, just like some of my other touring musician clients do with the Make a Wish and other foundations, that staff would pay for travel accommodations for his fans when they could not themselves afford to attend a performance. This is touring rock and roll, not a criminal enterprise. Remember, the band gives out free passes at every show and comps indigent travel at every show for about 30 years. And the government says five Jane Does in 30 years create and encompass the definition of how Roberts' tours and fan experience on hundreds of shows were run. The tie in to Rico is simply without merit. The indictment letter describes what seems like standard security protocols for securing the safety of visiting fans, groupies, or the like. The security measures allegedly imposed seem more to warn against alone travel throughout a hotel for the fans' own protection, caution that dressing too provocatively could cause attention to the band's presence in the hotel and cause problems with hotel management. Protect the fan against ingesting a food or beverage that may not have been screened first, and other measures to assure the fan's protection and make for the safest, most enjoyable fan experience rather than something more nefarious. Again,
One
in
second.
third,
I want 1 second. Do you know this is a response to a bond hearing?
huh?
Okay.
Hmm.
Go ahead. Keep going.
Again, okay. All right. Okay. Again, in 30 years of touring and providing male and female fans with a fun and enjoyable fan experience, the government cites what amount to only five Jane Doe alleged victims. The New York alleged victim we know was adult when she met Robert for the first time and never sought to file criminal charged on her own charges on her own, I guess that's what he meant, but
Yeah.
instead currently maintains a civil lawsuit against Robert seeking millions of dollars in money payoff. If this was the pattern or enterprise the government seeks to make it out to be, is five disgruntled groupies, not all of which are alleged to be underage, who now show groupie remorse so many years later, and only after a TV show and an aggressive, vocal Cook County prosecutor makes a public cry for victims come forth, tell your story, and be famous, really what the United States government seeks to make into racketeering activity? Finally, the government alleges that this enterprise only sought out real fans from the word fanatic, okay, who loved and were committed to the band and did
It's
their
funny.
best to pay for the fan to be well groomed, given show tour t shirts and the like, and be ready to enjoy the show. The government also alleges that there were rules and regulations for fans to follow, such as disclose their name, age, address, phone number, and personal information so they could be best vetted out and put on future fan mailing lists, and that they be obedient to following rules which were set up for their own protection. As for the allegation that Robert ever sought to keep anyone locked away and or away from their family, that repeated mantra has been beat to death as it relates to his two living girlfriends who, after his recent incarceration, were, if captive, now free to run, but are instead found online and in person supporting Robert. In fact, they are appearing in New York of their own accord on their own dime to support the man they have loved for so many years. It's time for the rumors to stop making their way into the hollowed halls of the federal courts. The government cites, and he gives a cite for the legal definition of enterprise in order to make the stretch of all stretches and define the rock and roll employment of professionals and mutually desired and competitive fan and groupie celebrity experiences as akin to criminal conduct for the sole purpose of brining same with what
Supposed to be
within
bringing.
yeah, bringing same within, I guess, within the purview of a racketeering activity. This court should not be fooled by the wrapper of the package, but recognize the contents for what it is. Okay.
Yeah. In this next, yeah, in
Okay.
this next one, this
Oh, read the
paragraph
next
you're
one.
about
Read
to
the
read,
next one. Read the next.
yeah, this is
Okay.
about to get you.
While I don't think I have ever before quoted Van Halen's singer David Lee Roth in a legal writing, I urge the court to click this link for a very brief overview of the industry accepted, understood, and agreed upon by consent definition of the fan and celebrity groupie experience. Click the link. Okay. The superseding indictment globally for all 5 Jane Does alleges over 2 decades of complained of conduct where Robert was the leader of the racketeering enterprise as described above. The government advises that this conduct affected only 5 Jane Does in that 20 years and that they are spread out in Illinois, California, Connecticut, and New York.
Look, hold
However,
on, y'all. You notice how he kept saying five, five, five. Why do you
right.
think they put in the uncharged Does, Jane Does now?
Oh,
Get it?
Wait, say what now?
He kept mentioning there was only 5 people out of all these years. Only
Mhm.
five, only five, only five. When they came
Mm,
in at the end, what did they do? They put
yeah,
uncharged Jane Doe to make it more than 5.
yeah,
mortified. Exactly.
right, yeah.
Mm-hmm. Okay.
Because they realized that that didn't make sense. Okay.
Yeah.
However, so that we are clear for this bail request in our New York matter
Okay,
as
now
it,
you see it. You see that was bail. This
yeah,
is a
yeah,
bail.
but the thing is, he should have hit that first. I mean, the whole thing was he needs to show that he's not going to um
Be a risk.
abscond,
Right,
fly away.
right,
You know, you can take his passport, you can give him
mhm,
an ankle bracelet, you can do
right,
this, you can do that. We will let him out on our, you know,
yeah,
uh,
yeah, under our
yeah,
supervision.
under our supervision, our care, our
Mhm,
whatever. Okay, wow, he went through it like okay.
mhm.
However, so that we are clear for the bail request in our New York matter as it moves forward, our case here in New York only involves one victim, Jane Doe number 5. Jane Doe number 5 is not a minor, but alleges her first contact with Robert was when she was 19 and a fan trying to get with him and hook up. Relying on the government's recitation of alleged testimony and facts, Jane Doe number 5
Okay,
testified
that
that
I just want to tell you, Jane Doe number 5 at that time was Faith. They
fake. Okay.
changed the Jane Doe around afterwards, after
Wow.
the second superseding.
Mm, mm, mm.
Go
See,
ahead. I'm
see,
sorry.
that ain't right. Okay. Testified that she took Robert's phone number and thereafter voluntarily communicated with Robert by phone of her own free will. Number 5 then testified that she contacted Robert's assistant to arrange for her own free travel and free accommodations to come be a super fan groupie and attend one of Robert's tour dates in Long Island, New York. Number 5, after enjoying the show and having a great time, returned to her hotel room by herself with no one following her, watching her, pressuring her, etc. She went to sleep in her own private free luxury hotel room that night, safe and secure, after enjoying a great show without any interruptions from Robert or any one of his employees. There was no show the following night. Nothing more to do before she was to return home on a free flight. Therefore, Jane Doe number 5 was free to leave anytime she wanted. But alas, this 19-year-old woman elected of her own free will to stay. Number 5 says that the next day, Robert came to her hotel room. She does not allege Robert had the key, that he opened the door, or that she tried to keep him out or did not want him in the room. Instead, number 5 made it clear that Robert came to the door. She freely and wantonly let him in, and then she had sex with the same superstar musician that she, as a groupie, specifically intended to travel to New York to have sex with. She wanted him so much that she alleges that she did not require or even request that a condom be used. Number 5 did not complain to anyone thereafter that she was forced, raped, or even upset about the encounter. How could she? It was exactly what this consenting adult woman wanted to do and was free to do without anyone judging her or telling her what to do with her own adult body. Okay. Number 5 goes on to testify truthfully that she freely and voluntarily communicated with staff and or Robert and voluntarily and intentionally boarded planes, got in vehicles, and stayed at hotels, all so that she could continue to do what she wanted to do, which is to see Robert's shows and see and spend time, romantic time as well with Robert. Number 5 swore under oath to the government that she voluntarily flew to see Robert, waited for him for hours sometimes, and then when she saw him, voluntarily engaged in mutually desired sexual acts with him to please herself and Robert, never once concurrently going to police or anyone and claiming she was forced, threatened, coerced, or the like. After this, number 5 again swore that she voluntarily flew to New York to see and spend time, sexual time with Robert, just like any adult groupie has the right to do. She advised that she again had consensual sex with him of her own free will. Thereafter, Thereafter, number 5 alleges again of her own free will she chose not to see Robert anymore. Sometime later, number 5 claims that she contracted a sexually transmitted disease. With no examination of her sexual partners over her life, this otherwise voluntarily and admittedly promiscuous number 5, wow, okay, number 5, who claimed she had unprotected sex with the music superstar on only the second time they met, claims that the only person she could have contracted this STD from was Robert. The government seems to indicate that even without a signed HIPAA release from Robert, they have somehow obtained this medical record, and that same show Robert had an STD, which they imply or claim with enough certainty to charge him on, that they have done the necessary scientific analysis to find conclusively that both are the same scientific strain of virus, and that they have done the necessary medical testing on both parties to prove an exact timeline of who gave what virus to whom and its viral life. Or have they? Has the government done any of the necessary scientific medical testing to prove such a correlation or causation in this case? Well, we don't know. But they certainly did not ask Robert for a blood sample or even make any inquiry of any kind to confirm any of the allegations. They just made the allegations because number 5 said so. An adult woman voluntarily met a rock star, eagerly and excitedly went to shows, hotels, recording studios, and the like, and engaged in sex with the rock star. Then she regretted it. Then she claimed that this rock star was the only person she had unprotected sex with for a period of about a year, and he must have been the one to give me an STD. Even if all that number 5 otherwise says is true, does it seem realistic that any rock star would risk his own life and have unprotected sex with a groupie he just met? The only criminal conduct that the government actually factually alleges that Robert committed in New York is as follows: reckless endangerment. A person is guilty of reckless endangerment in the second degree when he recklessly engages in conduct which creates a substantial risk of serious physical injury to another person. Reckless endangerment in the second degree is a Class A misdemeanor. A misdemeanor means an offense other than a traffic infraction for which a sentence to a term of imprisonment in excess of 15 days may be imposed, but for which a sentence to a term of imprisonment in excess of 1 year cannot be imposed. Second, exposure of infectious venereal disease. Any person who, knowing himself or herself to be infected with an infectious venereal disease, has sexual intercourse with another, shall be guilty of a misdemeanor. Of course, the government then does that stretch of all stretches thing I discussed above and seeks to tie in this adult woman's repeated voluntary behavior as a racketeering activity or a violation the White Slave Traffic Act, or the Mann Act, a United States federal law passed in 1910, which in its original form, the act made it a felony to engage in interstate or foreign commerce transport of any woman or girl for the purpose of prostitution or debauchery or for any other immoral purpose. Its primary stated intent was to address prostitution, immorality, and human trafficking, particularly where trafficking was for the purpose of prostitution. This is one of several acts of protective legislation aimed at moral reform during the Progressive Era. In practice, its ambiguous language about immorality has resulted in it being used to criminalize even consensual sexual behavior between adults. It was amended by Congress in 1978 and again in 1986 to apply to transport for the purpose of prostitution or illegal sexual acts. Our argument for this bail hearing, which will echo throughout this case, is that Robert is charged with basically two misdemeanor charges based on New York law as proposed predicates to RICO and Mann Act tie ins. There is no child pornography charge in New York, no underage sex charge in New York, and no sexual exploitation of underage children charge in New York. It's about an adult woman who voluntarily engaged in a relationship alleged by her to be sexual at times on a few occasions over the course of about a year until she cut it off. The fact allegation that she makes without any scientific proof of any kind to support saying, either in her civil case or this criminal case, is that she had a sexual relationship with the superstar R. Kelly and he gave her an STD. That one alone alleged fact is the basis for both misdemeanor charges, which the government then uses to trigger the much more serious RICO and Mann Act violations. Your Honor, this New York case amounts to nothing more than groupie remorse and a misdemeanor, yet unproven singular claim that during a completely voluntary consensual adult friend and sexual relationship, one party may have unknowingly given the other party an STD. Now he goes on with the legal argument, and you want me to read that?
Yeah.
Okay. Proceeding on mere proffer alone. The government proposes that it is entitled to proceed on its proffer in this pretrial detention hearing under United States versus LaFontaine. However, the facts in LaFontaine are completely different and offer no support to the government's current argument. LaFontaine dealt with a defendant already released and a rehearing requested by the government to revoke bail for what the government claims were violations of the conditions of said bail. While it is true that a district court may revoke an order of release under the Section 18, such a determination is not before us in our case. That case caused the court to determine either that there is probable cause to believe that the person has committed a federal, state, or local crime while on release, or that there is clear and convincing evidence that the person has violated any other condition of release. None of that applies to us. There was no violations in our case as Robert has been locked up since his arrest earlier this month. The government should not be permitted to proceed on just a proffer, which in this case is unproved. Okay, can I just stop right here? So the government used this case
Mm-hmm.
Hmm.
that
It's
really is
essentially
apples and oranges.
misdemeanors.
It's apples and oranges
Yep.
because
That's all they've been doing throughout the whole case is throwing out stuff that don't even doesn't make
Right.
sense.
And the judge, and that's what I'm saying, and the judge should have been like, wait. You're
this is
charging them
apples
with
and
what?
oranges. Right.
Yeah, you're charging them with what? I'm sorry, go back and fix that. That's
Right.
what the judge should have told Geddes. Fix
Right.
that. These are misdemeanors.
Right. Fix that. But also, for me to not give him bail, you are referring to this case, which is a hearing regarding someone who was on bail
On bail. Yep.
and violated his bail. He hasn't been given a chance to violate bail because he has not been granted bail. So that is okay. Let me continue.
Just like the case they just quoted with the not giving him the time, they quoted somebody who
Wow.
pleaded guilty.
Wow.
Robert didn't plead guilty. He
Right.
had to go through trial. So I don't understand what they're just throwing out any kind of case law and not matching it to what's going on.
Wow. And it's it's getting through. That's what I'm okay.
The judge is allowing it to get through.
I
So
know.
you
Right.
got to
That's what
realize,
Right.
I'm
not question some of the things that why she's doing it.
Right.
this is
Well,
wow.
when it goes to appeal, if they don't get Robert straight, and this thing goes to appeal, it's going to be ugly. Now, I'd like to know
Ooh.
I'd like to look up these judges and their records, the ones who would be in the appellate court should it go to appeal.
Oh,
Well,
we
it would
gotta look up
depend because the appellate court has several judges, and
Mhm.
usually it's three. It depends on who's up next.
Mhm. Mm.
So
Mm.
I
it
think it's
could
the
be
second district, I think, too.
right, but it could be 6 or 7 judges
Yeah.
in
Yeah.
the appellate court, and you
Yeah.
won't know until it's assigned
Yeah.
who
But at least
actually.
even if we're
But you can
able to
look
look
up
up,
all of them. You can
yeah,
definitely check out all of them
yeah,
In
to
the
see
record.
how they, what
yeah,
they do.
kind of what their flow is.
Yeah, because
Hmm.
once they decide, it's one of them that will write the actual opinion once they come to their conclusion. But
Hmm.
this is quite interesting. Um, wow.
They
Okay,
can even use this stuff that was let
they
through. Yeah,
they will
there's
have
a
to
lot
look
of
at
mistakes.
everything. Yeah, they would
Yeah, there's
look
a
at
lot of mistakes.
everything.
Well, and it does, and it appears that because when you look at the recent trial that just concluded, you can tell by this letter where Geddes and them was like, okay, let's tighten up here, let's tighten up there, and that was making me think that Bongine ain't putting everything out in these strong motions that she's been writing. I think she's putting out just enough for Geddes and them
Right.
to take the
She
bait and
she's
try to think
she
they're gonna modify,
she's
and Bongine gonna come through with the home run.
But see, the thing is,
right.
Geddes was
She's not
dealing with
playing.
attorneys. Go ahead. I'm sorry.
No, I'm saying Bongine is playing chess, not
Thank you.
checkers.
Exactly. That's exactly what
That's
I'm
what's
saying.
about to happen. Because I know she's seen all this
Oh,
and the arguments that have been
oh yeah.
brought forth in the beginning.
And was able to see how they modified from this to
Yes.
where they came, the case that was just completed. So
Wow.
she got them under wraps. I'm disappointed in this judge. I'm
Wow.
disappointed in this AUSA.
Wow.
This thing is crazy.
Yeah. Okay. Okay. Oh, the government should not be permitted to proceed. Okay. Which in this case is unproven, unsubstantiated, unscientific allegations by a disgruntled adult groupie that
Mm.
during the same year time period that she completely and consensually conducted a relationship she claims she had with a rock star that she contracted an STD. Where is the proof that she had an STD? Where is the legally admissible proof that Robert had an STD? Where is the scientific proof that the two STDs, if they exist at all, are of the same strain? Where is the documentary evidence to show who possibly had the STD first, if at all, and who gave what to whom? Respectfully, case law provides that this court has a right to require more than the he said, she said, yeah, ragtag, okay, completely unsupported allegations that are before the court at this time. I remind the court that number 5 has filed a civil matter against Robert for the exact claims and has yet to produce even one scintilla of evidence to support he gave her an STD.
And this right here should have been enough for her to say, damn. You
Yes.
done filed a civil case, and now
Yes.
we up in here got this man on jam with a federal case, and she still ain't provided any proof.
Still haven't.
She should have
Wow.
said out, just ripped this letter up and said, let the man out.
Yeah.
But here's the deal: he went on trial, and the jurors found him guilty without
Without
evidence.
any proof.
Yeah.
But if you notice in the trial, didn't Geddes establish, because didn't they call Rob's doctor and
Yeah,
establish the fact that
but
he was,
remember the test he did showed negative, but then he said because of the medication
outlets?
working and all that,
Mhm, mhm.
he kept saying herpes, but there was no scientific.
Conclusive test.
Right,
Yeah, there's no blood test done, none of that. It's
right,
just his opinion.
right. But that's what I'm saying. It's like Geddes and them read this, and then they said, "Oh, okay. Well, we better go ahead and, because if they wanted to call Rob's doctor, they would have had that in there too." And
Hmm.
even like he said, they didn't even have his medical records
Or hers.
or any blood specimen
Or hers.
or
Where's number
hers.
5's results?
Yeah. So Geddes and them said, "Oh, okay. Well, here's the cross off in which to make sure that we, fix our
It
case with."
it seemed like everything that they that was written in this letter, they went and fixed it later on and added it to it.
Exactly.
Wow, wow. Because so basically he pointed out all their holes, and they decided, oh, now we got to fill the holes.
Got some
Yes,
But that
spackling.
that
yes,
Got to
shouldn't have
tighten it
been.
up.
See,
yes.
there should have been question and some more stuff about, oh, what?
All I think is William Ray the third or the second or whatever. He wouldn't. This case wouldn't have got this far.
Mm-mm.
Not on this
Oh,
evidence that Geddes and them presented.
yeah. Yeah. Okay. It is well established in this circuit that profers are permissible both in the bail determination and bail revoca- mm, re- mm,
Revocation.
revocation context. See examples United States versus Davis, blah, blah, blah. In Davis, this court stated that it would not be an abuse of discretion for the district court to permit the government to proceed by proffer alone. As in the case of other pretrial proceedings, such as arraignments and probable cause determinations for warrants, bail hearings are typically informal affairs, not substitutes for trial or even for discovery. Often, the opposing parties simply describe to the judicial officer the nature of their evidence. They do not actually produce it. This is U.S. versus, he cited two cases. Nevertheless, this court has also recognized that while the informality of bail hearings serves the demands of speed, the magistrate or district judge must also ensure the reliability of the evidence.
Which she did not.
Exactly. By selectively insisting upon the production of the underlying evidence or evidentiary sources where their accuracy is in question. Now, in the Martyr, a case where the government argued that defendant posed a risk of flight and proceeded solely by proffer, we stated that in the informal evidentiary framework of a detention hearing, the methods used to scrutinize government proffers for reliability must lie within the discretion of the presiding judicial officer, informed by an awareness of the high stakes involved. In that case, the court criticized the government's proffer for simply stating in general and conclusory terms that it hoped to prove, for failing to refer to any independent evidence such as tapes, documents, or photographs, and for failing to furnish any testimony or affidavits. However, because the defendant in Martyr did not object to the proffer, we did not find that the district judge erred in relying on it. We object to the proffer of the government. The government has not offered anything more than general and conclusory terms that it hopes to prove Robert gave an STD to number five. Truth is, medically, anyone who knows will tell you, including the experts we intend to retain, that the first lesson of herpes transmission is that there is pretty much no way to know who gave who herpes for a number of reasons. The symptoms of a herpes infection vary widely from person to person, and most of the time there is no clinical manifestations. Kathleen Page, MD, an associate professor in the Department of Medicine for the Division of Infectious Diseases at Johns Hopkins University School of Medicine. The thing is, it's possible to transmit the virus without you have symptoms or not. In fact, most transmissions occur from people who don't have any symptoms and do not even know they are infected, says Dr. Page. Now, this court can and should take into consideration that the government has no independent evidence of this alleged criminal conduct. It is wholly relying on the word of number five. So, support each and every allegation made in her civil complaint and transferred to this criminal complaint indictment. Thus, it is no surprise that the government completely fails to refer the court's attention to any independent evidence, such as tapes, documents, or photographs, as this court can preliminarily require the government to do. Otherwise, how can this court see this matter in any other way that if anyone shouts, "You gave me herpes," without any proof that a U.S. citizen can be locked up and refused release without any evidence? That is not how our judicial system works. Now, the Bail Act reform. Under the Bail Act reform, Federal courts are empowered to order a defendant's detention pending trial upon a determination that the defendant is either a danger to the community or a risk to flight. A finding of dangerousness must be supported by clear and convincing evidence. He cites several cases. uh, the Bail Reform Act lists four factors a court should consider in the detention analysis: the nature and circumstances of the crimes charged, the history and characteristics of the defendant, including defendant's character and financial resources, the seriousness of the danger posed by the defendant's release, and the evidence of the defendant's guilt. In our instant case, we look to see if there is even a slight amount of evidence to support a probable cause finding that Robert gave number five herpes. The government has offered nothing other than number five's word that she has herpes and her allegation that she got it from Robert. The government alludes to having Robert's medical records that they believe may nor may not demonstrate that he too may have herpes, but they did not disclose if they properly and or legally procured same. If they have factually and scientifically established it's the same strain of herpes, or who had it first. For example, if the government says that Robert's medical records suggest that he had herpes at a time that predates his meeting number five, do they also have number five's medical records that shows she was tested for and was herpes free prior to meeting Robert? And has the government confirmed it's the same herpes complex or strain by doing the necessary tests? Or again, is it just a she said again standard that the government wishes to follow instead of the proper standards and laws set forth above? Under the analysis above, let's review the nature and circumstances of the crimes charged. Who has and who gave who the same strand of herpes so that the causation could be confirmed? And depending on the answer to that question, did the person giving the other herpes know themselves that they even had herpes? Remember the charge violation, exposure of infectious venereal disease states that any person who, knowing himself or herself to be infected with an infectious venereal disease, has sexual intercourse with another shall be guilty of a misdemeanor. So the law requires a specific knowledge that one be infected.
Now that's
Has the
good right there.
Yeah,
That's good right there. He did good there.
he did good right here. As the government even attempted to prove that, number five has had her civil case pending for some months, and she has not been able to prove a scintilla of her allegations and has offered no evidence to support her claims that Robert gave her herpes. While the history and characteristics of the defendant, including the defendant's character and financial resources. The defendant has been law-abiding citizen for his 52 years on this planet. He is loved by millions around the world and promotes love and peace through his music. He was accused and charged with criminal conduct in the past and was found not guilty by a jury of his peers. Like anyone else in life, he has engaged in consensual conduct with various people throughout his life, possibly more than normal people because he is a rock star. But sheer numbers, if they be great, and the lack of any other similar claims akin to the ones in this case, only further support the defense's position that number five claims are without merit. It is no secret that Robert is having financial problems. He has no money. Myself and other attorneys in this matter are working now without compensation. The breadth of unsubstantiated charges and the hashtag Me Too bandwagon movement had made it impossible for him to get paying gigs for the last several months, and as a direct result of the injuries sustained by the unfounded, uncertified claims made in Lifetime's surviving R. Kelly, none of which claims were made, he meant were made, under oath or any kind and free from the laws of perjury, have rendered him without means. Robert surrendered his passport and has no money to go anywhere. In fact, even if a reasonable bail is set in this matter without reasonable conditions, he is certain to remain in custody because there has been a denial of bail in the Illinois related case. But that should not stop this court from still properly and legally addressing the New York bail application separate and distinct from the other charges when setting a bail and release conditions. Number three, the seriousness of the danger posed by the defendant's release. There is zero danger posed by Robert's release. What is the claim in the New York case? That he will get out of jail and go randomly and have unprotected sex with other consenting adult women who love him and are groupies? Really? Like, they won't have heard about this case already and not engage in such conduct? Like, he is a threat to number five, one woman in 30 years of being a rock star, and there is a concern that Robert poses a danger. Robert cannot read or write. To suggest that Robert wrote a letter to number five or her lawyer is an absurdity. Again, no evidence, just assumptions based on no evidence. My office receives prank calls all day long from people claiming to know this or that about the case, or that they are victims and they want money, or calls advised that they have negative or derogatory information on everyone from me to other defense attorneys or even the AUSAs, and for a price, I can have the information. At first, it was funny, but now I have instructed my staff to get names and phone numbers of these callers to address in the future. The lesson here is saying so does not make it so under the law. There has to be some evidence that arises to the applicable standard of review. Number four, the evidence of the defendant's guilt. Zero. Currently, there is zero evidence that Robert has herpes, knew he had herpes, or knew he could have herpes and recklessly conducted himself. Zero evidence exists. All that exists is a disgruntled groupie who alleges she has herpes and got it from Robert. There isn't any testimony where she is asked if she had any other sexual partners over that same year period or any time thereafter, but before she was diagnosed with herpes. This is no evidence at all. And in fact, given the opportunity for the last several months in the civil case, she has not been able to provide one scintilla
If he says
of,
scintilla one more
I
time,
tell you, of
okay?
evidence to support this same claim in that case. This court is rightful when it concerns itself with, will this defendant appear in court? Is he a danger to others? And is he a flight risk? I have represented Robert in this pending matter in Illinois State Court and in New York State Court. There has never been a court date that he was aware of that he did not appear. He is always on time and fully compliant with the court and his probation officer's demands. Kindly be reminded he was permitted bail in the Illinois State Court criminal matter and is fully compliant at all times. Robert wants to address these matters to their conclusion. In fact, the defense had to fight the Marshal Service last week in federal court in Illinois to make sure that Robert was allowed to appear in person in the New York for this week's arraignment. Not only can this court feel comfortable that Robert would appear in court, but it can rest assured that he will legally challenge anyone who tries to keep him from coming to court. Furthermore, Robert presents no danger to number five. They live in completely different states, and she has never once even sought a restraining order of any kind or even suggested the need for same in the civil case or at any time during the relationship or since it ended. Lastly, as stated above, Robert does not have his passport, nor the means, nor the desire to run from these cases. He was wrongly charged before and acquitted of all charges and fully expects to be again. More than his alleged victims, he wants these cases to move forward to their logical, proper conclusion so that he can be vindicated once again and get on with the business of writing incredible music and performing the same.
Uh-uh.
We proffer that under the facts that are before it, that is, the singular acts complained of by only number five in this New York matter, this court could not conclude that no condition or combination of conditions will reasonably assure the appearance of the person as required and the safety of any other person in the community, and therefore a reasonable bail should be set, along with any conditions the court deemed necessary, if ROR is not allowed. In a case where the predicate conduct is two misdemeanors that we are even having a discussion about whether or not there should be bail should be offensive to the law. If these charges were brought where they rightfully should have been brought in New York State criminal court, there would be no need for bail, but an easy ROR, release on overcognitive, that's what that means, release for 2 misdemeanors and no victim contact order, so as not to deprive the accused of his constitutional rights. But for the stretch of stretches the government is making, trying to tie 2 state misdemeanors into a RICO and Mann Act conspiracy, this should be a no-brainer. But the court has to now make determinations, which we understand is part of the process. With respect, based on the underlying facts in our New York case, it is a misuse of the law and possibly inadvertent bullying by the government to say that just because they charge RICO and Mann Act violations, that our facts could be considered racketeering acts so as to be predicate acts alleged as part of a pattern of racketeering activity, which can trigger a rebuttable presumption of dangerousness to community. That ship won't sail in our New York number 5 case, and we are confident that this court won't be fooled by the same. Well, in our case, we don't need elaborate bail packages or to even argue for the same. This is not a dangerous defendant who even requires home confinement, surveillance, electronic bracelet, or other condition. Robert goes 5 places: home, studio, gym, church, and cigar lounge. We have a defendant charged with 2 misdemeanors with no causal connection to any larger conspiracy. We ask the court to simply do what any New York State court judge would do and release Robert on his own recognizance with a standard no victim contact order, except obviously to defend himself through counsel in the bogus civil matter pending by number 5. Why? Because it's the right thing to do under the law. In fact, there is really no other way to go, according to the law. But the court and the government can rest assured that Robert still will not be released because he still has some more serious charges pending out of Illinois. So, by each federal judge following the applicable law and applying same to the specific, independent, and unique facts in each case, these matters are assured to be properly and fairly addressed in each district. As a result of the above, we respectfully request that Robert be released in this matter as he would on any matter involving 2 misdemeanors, that is, on his own recognizance. Due to the pending other charges in Illinois, Robert will not be released, of course. If, however, the court elects to set a bail and conditions regarding same, we ask that the court review our arguments above. The government's case, its ability to proffer anything other than a she said argument, and set bail and conditions for release to something reasonable, perhaps concurrent to what his bail is in the state court matter in Illinois. We do not in any way feel that this New York case warrants pretrial detention as the government has requested, without evidence to support its reasoning in this specific New York allegation fact pattern. For the foregoing reasons, we respectfully submit that the defendant should be released from custody on his own recognizance and in the strictest case with a reasonable, possibly concurrent bail. We acknowledge that in either release scenario, Robert will still remain in custody unless and until such time as an Illinois district judge orders his release, but we still request that a purely New York case determination is made as to pretrial release at his arraignment on Friday, August the 2nd, 2019, submitted by Douglas Anton. Wow.
Woo! Thank you so much. Thank you, thank you, thank you.
So coming up August, he'll be incarcerated 3 years.
Wow.
No, July.
July. Okay.
Okay.
Wow. Wow.
That's a
Well,
lot.
That's
now
wow.
for bail hearing, he had some good information at the end, some good stuff, but
But
for a
yeah.
bail hearing, that was not.
Yeah, how he started off, you wouldn't have thought that that's what it was about.
Right. I mean, and I'll even give him props for trying to be somewhat conversational in this 12-page document, but I don't think, I mean, it's definitely not Bongine. That's certainly not.
Right. Yeah. She kind of hits it right on.
Yeah, because
Boom.
he
Goes
was
straight
adding too much.
Yeah.
And I think he probably was exercising a little privilege, like, I'm white and you're white, Judge, so
Yeah. So
you know how it
let's
is.
just
Come
get
on.
with it.
Mm-hmm.
Yeah.
Get down with it, get down.
Yeah. I know you've been to the rock concert. What?
Van Halen.
Really, dude? Really? Wow. 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 Wow.
But overall, his argument is good. But again, I think that Getty's read this, and she probably highlighted and underlined stuff on here.
Oh, definitely.
You
Oh,
know,
we gotta
make
cover
sure
this
you get
hole up.
this. Yeah.
Hmm.
Mm. But
Wow.
even this attorney is making it clear that they have misused um, charging him with RICO and Mann.
Yeah.
He made that clear.
Wow.
What is it? In
Wow.
52
Yeah, but see, the
days for
thing is,
misdemeanor?
to this day now, Faith has not produced any kind of medical record in her
Wow.
case.
Wow. Wow. Wow.
Mm.
And the thing is, documentation is supposed to, quote unquote, is what wins the case. The documentation, the evidence. But if you and hearsay and she say it's not proper.
It's not
And
evidence.
she didn't even do it as an affidavit. It's like she said it,
Right.
we going with it. What the world?
And you know what? And Kel's attorneys, if they was on top of it, they would have objected to this coming all the way out the gate. They
Yeah.
would have when they had him when they brought him in for questioning. I don't know how
Yeah.
the process went, but they would have been like, "No, prove it." And if
Right.
they proved it, they would have said, "When you got proof, call me."
And misdemeanors? You're not going misdemeanors?
Yeah.
And
See, this is
I saw a video with Faith on there talking about that she had a boyfriend who was abusive to her. I couldn't make clear if it was before Robert or after Robert. I want to say it was before him.
before. It was before Robert.
Mm-hmm. Mm.
And wow.
Guys,
Wow.
what I'm doing is just giving you guys some concrete stuff that actually happened in
Some
court.
context and
So,
insight.
yeah, so you guys can see why we fight the way we fight, and this is for a lot of people who are against Robert, and I want them to see what happened, why we believe this man was railroaded. There's no possible way. I don't care how much you hate him. There's no
Wow.
possible way you should agree with what happened in court.
Yeah.
Do we
No
have the
possible way.
response from the judge when she said, because I would like to have seen what she said. Because there's no way. I mean, this lawyer is as convoluted as this motion is, he made it clear, hey, look, what you charged him with was misdemeanors.
Right.
So how does the judge square that and deny him bail? And I also don't think that this attorney should have been saying, even if you do grant him bail, he's still going to be locked up in Illinois.
Yeah,
There's
that's
no
not
need
the
for
But
point.
that.
but let me tell you what they did. The judge herself was not the one who did the arraignment for the bail. They put
It was the
another judge
magistrate.
there. It was a magistrate judge went in and did it.
Yeah.
So the letter, I don't know if that judge even went to even look at that letter.
Mm-hmm.
Since it was addressed to Donald.
Donnelly, yes.
Mm.
You see how the games they played?
Yeah. Oh boy.
It's a lot, guys. A lot of craziness that has gone with
Perspective
Robert.
B just said Jennifer pointed out she never got genital herpes.
What?
Yeah. We read it. We read it the other day, Mel. You read it.
Mm.
What?
Yeah, I thought that. If
Yeah,
not the other day, I thought I read it at some time.
yes, you did. read
Are
it.
you serious?
Yes.
Oh my goodness.
Wow. Oh, she got a lot of ammunition.
Oh yeah. This case. I mean, Robert's coming home. It's just a matter of time.
Yeah, and the
That's
process, going through
problem.
the process, having to go through the motions, respond, motion, respond. It's that back and forth. Oh my gosh. Mm.
Well, this is all I want to give you guys for tonight. I don't want to keep overloading you guys, so just stay tuned because we have a series going on. We're exposing, and some days we're gonna be on Mel's channel because she's getting prepared for the other stuff, aren't you, Mel?
I really am, girl. I'm making calls. I'm trying to pull some strings. You heard?
Mhm.
Yeah.
I really
Now,
am.
well, okay. The thing we wanted to talk about too. I know it's a lot, guys. I'm so sorry. It's just that trying to get everything in at once. Okay, not all right. Did you guys have an opportunity to see the two interviews?
It's sickening me.
Yeah, I couldn't finish
I couldn't
watching
either.
that
Me
one
either.
with Jason. I
That
wanted to
bothered
come
me.
through my computer.
First of all, why are you sitting on Jason's couch with your bare ass?
Looked like
Yes.
she had on underwear, didn't
Yes.
she?
Your bare
Yuck.
ass.
Yuck and yuck
Jason is not wanting you. And
at
see
all.
this thing, that's why I say it's very bothersome to me.
Yeah. Yeah.
Very bothersome. And what she did say in that interview, she says, "Well, no, the only person that really should just be Kels." Wait a minute.
What? You do
Only
you not?
only Kels should be in jail. What about you for lying about your
Ah,
age?
wow. What about your mama? What
Thank you.
about your text messages? That's why I'm like,
Well, hold
Jason.
on, now. Hold on a second. I want to
Mm,
bring in another interview that happened
mm,
today. Shout out to
Today.
Toxic Diamond. Toxic Diamond had a guy in Dubai
mm.
who says that she was
Prostituting. I read some of that the other day, and
no. He had her. He was on the live today.
mhm,
So you got to go to Texas
black, yeah,
Toxic Diamond, sorry.
yeah.
Toxic
Toxic
Diamond.
Diamond. Toxic Diamond. Go to Toxic Diamond. His
Did
name is
she vet
Kevin
that person
Silverman.
though? Did she vet him?
Go
Did
listen
he
to
have
him.
like text messages or whatever?
Go listen to him. You'll see
See,
difference.
some of that stuff I can't even put it in my spirit because it's, like the snippet that's going around where she's on the phone talking to Kels and Kels is crying.
Yeah.
And that
Yeah.
just bothers me so much. And here she says, "Nope, that's it. You lied to me, bitch. You lied. You lied about your age.
Yes.
You don't do that." And all of a sudden you're righteous. See that?
Because she wanted to control the money.
Well, when she said you're locked up, Joy's locked up, and hopefully you make it to trial. What?
Wow.
I just can't give that none of my personal energy because this is a problem. And I wish Jason Lee, which shout out to Jason Lee, nothing against him, but I wish he would have got in that ass and said, "Hey, wait, hold up." He should have checked her. But see,
No, but you gotta also understand. Have you heard Shabazz's thing? There's a method behind this. Jason Lee is with those that is
I'm
against
thankful.
Robert.
Yeah, he is, and
I'm
so is
thankful.
that other girl. That other girl. She was like, does Bonjean? How did she eat at night, sleep at night, and blah blah blah. I'm like, what?
But remember who is behind that station? It's the guy who used to
Fox.
date that guy that used to date Aaliyah,
Mm.
Damian
Dame
Dash.
Dash.
What station? Wait, hold on, clarify.
Fox Soul.
Oh,
And Hollywood Unlocked is on Fox Soul.
Yeah.
right, okay.
Mm.
Yeah, I just can't give it no juice because it's just
It's draining. That's why I
it's really
can't
draining.
watch that stuff too long.
Yeah.
I didn't watch the whole interview, but it is very, very, very draining because you're getting a lot of that negativity inside your spirit. And that's why I
Right.
tried to limit it.
Right.
But it was just like a lot this week. A lot. And I
Well,
said,
I
And
mean,
lies. And
and
she's acting
people
like her family is so perfect, and we eat dinner together every night. And
and yeah,
what?
I mean, it's just too much.
And you notice she didn't say nothing about her supposedly trying to commit suicide. She never talked about her being in a bad
Wow.
relationship
Well,
before.
the way she was
Everything
looking at
was
Jason was, I
wonderful.
wonder, can I turn you? That's what.
Yeah.
Okay, I
Yeah.
wonder if I might have a shot. And she also said that even before Kells, she goes, "Oh no, I wasn't a fan. I wasn't a fan girl or or fangirl, and as they say, I wasn't doing all that. I've been around celebrities before.
Yeah.
Where and who?
Before, she was saying before she even got out of high school.
But who and
So
where?
thank you. And who? But
Right.
but that was probably the truth. And that's what I'm saying. That's why you don't get to say, "Oh, I didn't, I just didn't know
Had no
he
care.
manipulated me and
Yeah.
took advantage of me." Nah, boo-boo. Mm-mm.
Mm-mm. It
No.
was a total setup with y'all text messages.
Thank you.
Come on now. And
Thank
that's
you.
why I'm like, did Jason Lee ever hear that? See the evidence? That's evidence. That is text messages. That is not
Right.
made up stuff. That is real.
Right. And we know that
No,
if
what I
Jason
did is, yeah, I had sent him the stuff, and I even called him today. He's not interested in hearing the truth.
Well,
Wow.
it's all good. Yeah, that's what I was just going to say is that, had he been aggressive or assertive with her, she could have walked off, and
Mm-hmm.
or declined to interview because certainly whoever invites her to do an interview, she's checking their social media. She's checking to see if,
Which
if they're
side
for
you
her
on?
or against. Yeah, she's checking
Mm-hmm.
it, which, it's calculating, and I would do the same,
Mm-hmm.
but I just can't take it. So I can't take it. And then to be on that phone and Kels is crying
Wow.
his ass off. No,
Mm-hmm.
Bear, nope, nope. You lied to me. You lied to me like you've been a truth teller your whole life.
Hey,
Like
you
you never.
notice he called him Bear, not
Mhm.
Daddy, not
Right.
Daddy.
Thank you.
You notice
Right.
that?
Like
He
Right.
didn't
like
say
she
Daddy.
ain't never told a lie.
Yeah. And so why if he make you call him daddy, why you calling
Daddy,
him bear?
Bear.
And he calling her Bear right back. Oh, Bear, please. I mean,
See,
that tore me up. I just can't. I can't.
Wow.
that man shed so many tears, y'all. So many tears.
Wait, Good Design
Mm-mm.
said she was drunk on IG last night. What?
She
Yeah.
well, she looked like she was high or something in the Jason Lee video.
Well, she probably thinks she got a shot probably got a shot with old Jason Lee.
Mm,
And he
mm,
cute.
mm, mm,
I'm just this is very her and then Faith getting up there with all her breasts showing.
mm.
You know what I mean?
Yeah.
But and she goes, "Nope, there's nothing he can do for me." Because I was gonna try to put something together, y'all, but as I was going through this stuff, I was like, you know what? It's taken way too much out of me emotionally, and I need to have some interaction. I can't, I need to cuss one of these out.
Yeah. For sure. Mm, mm, mm. Man. Too
They want
much.
us to believe that this girl was innocent coming out the gate with her little 1 minute 19-second song.
Mm, mm.
I just can't.
And you could tell to me that she is like, I mean, if you really look at her, she is a serious she's acting.
Hmm.
She is surface.
I wonder if
This
I'm blocked on her Instagram because every time I click on something, it's like, sorry, this page is not available.
she is surface. She is so surface. Mm-mm-mm. Oh my God.
Has anybody else went to her IG to see? Because every time I click on anything, it
What is
says
it? Is it called? What
Azriel
is it?
Most Wanted something. Let me
Okay, let
see.
me check. Let me
Yeah.
see. Um,
Yeah.
okay, I'll
You got to
open.
be blocked because every link I'm clicking on says unavailable.
Okay, yeah, because I just hit on one of her
Did it,
videos.
did it
It,
produce something?
it came up.
Oh, yeah. So I'm blocked. Okay. Well, feather in my cap then. I've been
And
blocked.
her song "Sounds of an Angel" and "You in Black."
Mm-hmm. Yeah.
An evil angel.
Thank you.
And don't even say angel. You
Oh,
just should
yeah.
have said "Sounds of a Demon."
Ooh. Yeah, I'm blocked.
Wow.
I'm blocked. I don't care. Shit.
Why she blocked you? You didn't do anything to her.
Well,
Wow.
Maybe she been watching your page.
something. I mean, I know some people that know some people, so they probably say, hey. Because I don't comment on none of her stuff. It's all good, though.
Well, she has a thing where you rate. She show you rates for her to promote your her stuff.
Please.
Mm. Oh,
What?
I see some people following her that. Oh, they definitely must don't have a clue.
Maybe they're trying to get both sides.
Mm.
Maybe.
Well, anyway, good people, I thank you guys for being here. I just wanted to give the insight of some things. We're still going to be doing a series. We're going to be doing that series. I started yesterday. We're just going back for over some things and opening up some eyes. As
Okay.
usual, thank you, ladies. I just because I know you have your flea market
Yes,
tomorrow.
that's exactly what I was about to say. So
Okay.
I'm about to tune out.
Any last remarks, ladies, before we get off?
No.
No,
Just-
that's all I can say.
Yeah, me too.
Yeah. Well, thank you again. I appreciate you guys for your
Absolutely.
diligence. And Mel, when are you going to be on to do our
Well, actually, I'm about to do this thing on Trey Songz because I know his stuff is still swirling. So that's what I was working on today. And I said, well, let me just chill. Whew. I don't know.
Yeah. I was going to tell you, speaking of Trey Songz, Snoop, his case was dropped.
Yeah, I saw that.
His federal case was dropped. So,
Awesome.
Kudos to him.
Yeah, yay for him.
Okay, well, I'm gonna have to leave you, ladies.
Right
Yeah,
on,
I'm
girl.
about
You all be blessed.
You too.
You too, honey. Good night,
All righty.
everybody.
Good
Thank
night,
you,
Chad.
everybody, for being here. Have a good night. Bye, bye,
too,
everybody.
Sylvia. See ya.
Thanks, Mel.
You're
Bye.
welcome. Bye.
Okay, ready? 1, 2, 3. Hold on now. Wait a minute, fellas. Wait a minute. I think it goes something like this. Whoa. 1, 2, 3, 4, 5, 6. Can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. Cause every time I turn around, there's something trying to keep me down. Can somebody take these burdens off of me? Off of me. Whoa, can somebody take these burdens off of me? Off of me. Can somebody take these burdens off of me? Off of me. When I look up, don't you know, burdens knocking at my door. So won't you come and take these burdens off of me? Off of me. Oh, come and take these burdens off of me. Off of me. Somebody come and take these burdens off of me. Off of me. Soon as I get up off the ground, my burdens knock me right back down. Can somebody take these burdens off of me? Off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Somebody take these burdens off of me, off of me. Well, off of me, off of me. Oh, off of me, off of me. Well, off of me, off of me. Get them off of me, off of me. Come and break the chain. Come and break the chain. Off of me. Get it off of me. Off of me. Get it off of me. Off of me. I need somebody. I need somebody. I need somebody. I need somebody to get this burden. To get this burden. Can somebody take these burdens off of me?